M, council shall have the power to subpoena witnesses. Is this language appropriate? Can council subpoena witnesses? Can we enforce? How do we enforce? Only a court shall issue subpoenas. And Jeff says there are times when council acts in an administrative capacity as opposed to legislative. When conducting these administrative or quasi-judicial functions, the council does have the power to issue subpoenas.
So the language is appropriate.
Yeah.
Never seen that done, but it almost looked like a kangaroo coming out of a pouch.
So
we're gonna say that's okay.
That's okay.
Jeff says everybody okay with that?
Well, leave it there. As long as we don't have to use it, we're okay. If we use it, we'll find out if there's a problem.
And we appreciate our term.
Okay.
Oh, you're not down under.
Section 206, ordinances and resolutions. The council. Addition of clear definitions of ordinance and resolution will probably be best be inserted in the first paragraph of this section, preferably as a second sentence or in the third paragraph where form and style is stated. Please give us concise, clear definitions of the two and requirements of each. And I have a feeling that this whole ordinance, we're going to spend quite a bit of time on.
Can we just say we'll all revisit that?
Well, yeah, it's further work, but I think we are. I think we've known it from day one because Jeff brought it to our attention, Yvonne brought it to our attention, the chief brought it to our attention. So I think that this is one that even if we ignored so many other things, this is something we can't ignore. That we need to come back, and it looks like he's given us some really good stuff here to help us, but we're going to need to work on it, I think.
It's worth looking at. There's no reason to reinvent the wheel if we don't have to.
And incidentally, Jeff said to me, he sent this to me, and then he said, I don't think I need to be there, but he said anytime that you want to talk to me further or when you get into the hard stuff, don't hesitate to ask for help if you need it. So
We might want to call him in, particularly on where we have the 2/3 and 3/4, because he mentioned there.
Yeah.
This is the only city or village he knows where you have 3/4 in one and 2/3
Yeah.
in the other. And
Yeah.
we want it pretty much consistent, with, internally consistent with each other.
So let's just say that definitely will take further work, and we know that. Okay. The paragraph leading into posting locations is still in that 206, isn't it? Yeah.
B, right?
Yeah.
I'm on B.
Yeah, B.
Okay.
And we asking by publishing the title of the ordinance resolution in a newspaper, circular, or other publication determined by council to be of circulation within the municipality or library or bank. And he said, I'm not sure what is being asked here. I asked Yvonne, that next section there, Yvonne mentioned the need to post in the public library to be compliant with state law requirement. Is this true? Does library reference Greenhills or the downtown main library? Concerning is whether Greenhills will always have our own local library. I talked to Yvonne further about this because I had forgotten some of what we talked about. And Jeff says the reference to the public library is concerning the availability of the codified ordinances book. It doesn't mean anything else. It doesn't mean the charter. It doesn't mean each posting of a new ordinance or resolution. But it's the codified ordinances book, the big one. A copy of the codified ordinances should be on file at the public library. This could mean that the local branch, but if the local branch is closed, it would probably mean that the main branch downtown. However, this has, bless you. Bless you. However, this has nothing to do, that's sort of a half bless you.
Wait till I'm done.
Gesundheit.
Yeah.
In our home, we say blanket bless you.
Blanket bless you. That's one, whatever. Yes, okay. However, this has nothing to do with the posting of each ordinance. It only concerns the codified ordinances book. Okay. So, going back to where this is listed out, I think it's on our page, whatever, 9.
I don't have page numbers. Oh,
No,
yeah, I
on
do.
the charter.
Not 9,
On
yeah,
the charter.
I got it.
No, it's on further.
So we're not on D?
Yeah, well,
That's on page 9 in my charter copy.
yeah, there it is, okay.
This is page 9, those of us that have stapled it.
Yeah. By publishing the title of the ordinance resolution in newspaper, circular, or other publication determined by council to be of circulation within the municipality. So,
Wasn't much of the discussion moving into the 21st century, putting it on email?
That's
putting it
correct,
on
that's
website?
correct.
it was, and one of the things that Yvonne said to me when we were talking about this, she said, we can't have it only on electronic anything. We can name that as another.
We're broadening
Yeah.
the places
Yes.
to notice.
Yeah, I
But
think
she
we really
said,
should.
yeah, that she gave me an example that even within the last month, our browser has been down twice.
Right.
Which crippled, communication. And so she said, we can't have that as the only way. And I said, okay, we can figure that out. We can mention it as an additional place, but it's an option that we can give. But we can't delete other ways of having it posted.
Yeah, I think the idea is to open it up.
Yeah.
I do think we should add D, I put in there D, internet. You can email as a method to do it. Not the only method, but give that as an option.
Right.
Because we have A, B, and C there, we should also put D. A is posting a copy of an ordinance or resolution at least 4 public places for a period of 15 days, or by publishing the title of an ordinance in a paper, etc. circulation, or by publishing a concise summary by council to be in circulation within the municipality. And I think you should also put in there E. And I would put up there at least one or more, or perhaps at least two of the following manners. Or put in there email and one of the other following. Because we're in the electronic age now, so
Right.
you should include it somewhere in there rather than exclude it, because
Take one of those two out, those two printed one, isn't there two
Yeah.
that are very similar?
well, if we get
C
back,
and D or
yeah, we should
there's
leave an
some-
option of at least two though, because as Yvonne mentioned, if you buy browsers down, it says at least one of the following manners. If the browser's down, you can't use it.
Mhm.
But if you put two or more, then you have, or put email and one of the following.
You don't mean email, you mean.
Or electronically.
Website posting.
Website or
Yeah.
electronically.
Yeah, yeah.
And probably call it electronic media or something like that,
Yeah.
because 10 years from now,
It's
we might not have
evolving
websites.
already so much, yeah, yeah, so,
Be on the watch.
so if we,
Yeah.
It might be in your brain.
hey,
You push a button and they'll transport you somewhere.
It's set in the 70s, there's no room left.
well, we could say at least two of the following manners, but the posting could be in A actually, to add it into electronic media.
Yeah, or,
You know,
yeah.
that we talk about for public places in a municipality is determined council, additionally, using electronic media.
If we make it at least 2,
Mhm.
that's gonna give
Yeah,
right.
some discretion.
And I think it's fine to add electronic media. I just, having a person in my house that does this for a living, I mean, the internet could blow up.
Sure.
I mean, I have T4 lines in my house, T1 lines, I don't even know what they are. All kinds of robotic stuff, and it breaks.
And the Enquirer's going out of business, so, you know.
Breaks.
Yeah, right.
So
I mean,
you
things
just need
happen,
two
and
easy things.
The internet could go down. There
Have you
could
watched
be-
Revolution?
But isn't B and C?
Yeah, I mean, there could be an
Yeah.
attack on.
Pretty much saying the exact
or
same
hurricane.
thing.
Close to it.
Well, we have the world standing here again.
A newspaper, circular, or other publications by
Christmas or
council to be determined, and then it's the same thing.
See it.
Ordinance in newspaper
Newspaper.
or other
Whoa, whoa, whoa,
publication
Whoa,
determined by council.
Wait, let's all get back to this conversation.
My bad,
It was
I
his fault.
apologize. Not my fault.
Okay, Heidi, start
Okay.
over.
I'm saying if you read B
Yeah.
and C, they pretty much say the same thing. In a publication, newspaper, circular, or other publication to be determined by council. And then C says, by publishing a summary of the provisions in a newspaper or other publication determined by council.
They're pretty much, B and C
Yeah.
are
They
pretty
both
much
say a
cognate.
publication determined by council.
Well,
One's the title and
One is
saying-
the title
One's
and one is
One's
the
the
concise
title.
summary.
If
Yes,
it's
I hear what
something
you're
that's
saying.
70
Yes, yes,
pages,
yes. Oh.
you might not want to publish it.
Yes, especially in the inquiry. Because it would cost you.
Sounds like
Yeah, so it's giving you the
$5,000.
option to publish the title or a
Okay.
concise summary, because
Okay.
if it's a 70-page ordinance,
Mhm.
you might not be able to get space.
Right, yeah, I see that, or be able to pay for space in the
Legal
Inquirer for
ads are
something like that, okay.
astronomical now.
And grammatically, that would need to be and or if we're making it at least two.
Well, and I think that we're agreeing that we want to work on this, that this needs to be reworked. And make note that if we could combine B and C into one statement
That could happen.
and add electronic media in A and 2 up above, it would give them lots of choices within all of that, you know. Like, so we just need to talk that out a little bit further and finalize it. So we'll work on that one.
Of course, what Mickey said, the Inquirer may be going out of business 10 years
Mhm.
from now. We
Oh,
may
yeah.
not have newspapers.
Yeah.
They're going electronically anyway. I think they're putting what electronic subscriptions out now. I'm looking forward to cynically, 5 years from now when I don't have that fresh print to read in the morning and smell.
Well, I habitually hit the Columbus Dispatch for political news, and I get 10 hits a month, and then I've got to sign up and start paying. It's not a free newspaper access.
Yeah.
No, it's
Oh,
not.
and that's what
They
the
start
Inquirer is
out
going to.
like
It's,
that.
it's moving
It's-
towards.
yeah.
Yeah, some of these things are sad to some of us, you know.
Yeah, I don't like it.
I'm so upset about the shoeing a horse. So there's no horse shoers out left anymore.
Do you need one? I know where you can find one.
A horse or a shoer?
A shoer.
Okay.
There's a lot of manure on it.
Right here.
Article 3, Mayor. Section 303.
Speaking of horses.
303, judicial powers.
Which part?
Okay. The mayor shall exercise all or any such powers in accordance with the procedure established by law governing mayor's court. Should this state and in accordance with, question was raised regarding whether this should read by the Supreme Court of Ohio, you know, in quotes. Jeff says mayor's courts are created by statute and are governed by chapter 1905 of the Ohio Revised Code. While the Ohio Supreme Court issues certain rules for courts, those rules generally only apply to courts of record. Mayor's courts are not courts of record. As such, the existing language should be sufficient.
I'd question that because if you look at the mayor's court, you no longer have a mayor sitting on the mayor's court. You
We
have a
don't today, but we
You have a
might.
magistrate.
I mean, that could happen again. And so-
No, it's not likely. The reason you have a magistrate is because of rulings by the Supreme Court of Ohio, who makes judicial rulings as far as dealing with court rules,
Right.
that even though it's not a court of record, they have to follow certain rules.
Right.
And they feel that there's a conflict, a constitutional conflict with the mayor, who's the executive officer of the village, also rendering decisions whether someone's guilty or not, as an ordinance, and also it's a money factor.
That's why we changed. It was the money factor.
Right, and that's why the Supreme Court pretty much designated in Ohio, you have to have magistrates. So the Supreme Court has its finger in it, whether we like it or not, it's there. And the Supreme Court is deals under another section of the Ohio Constitution, different than the legislature.
Right.
And we had a modern courts amendment about 25, 30 years ago that gave them all this authority.
Sounds to me like.
And you're excited about it, I know.
Well, no, he's just saying the existing language should be sufficient,
Yes.
and I know why we made the change, and we had big discussions about it at that time, and we did it financially, because we could, and because the Supreme Court okayed that. I mean, it was fine. We were able to make the decision ourselves to do it, put it that way. And so this does not limit us from doing what we're doing with the magistrate. Is that correct?
No, it doesn't do that. It doesn't limit the magistrates.
No, so we're fine.
That's what I'm thinking, and he's
Yeah.
telling us we're fine.
Yeah.
And it's not broken, so let's
No,
not try and fix
that's
it.
where I
What am
do.
I marking this?
Okay, this is
Okay.
okay as is. Section 306, qualifications. We feel that 12 consecutive months residing in Greenhills prior to the time of filing for office is not long enough for a mayor. Any restrictions from the state, are there any restrictions from the state if we recommend changing that to 36 months? And Jeff says the state law only requires 1 year of residency as a qualification for the office of mayor. However, I believe it is fully within the local authority to change that by charter. See no problem there.
No,
So,
they want to change it.
I think our last discussion, we were saying 12 months is too
Mhm.
short.
Yeah.
so we will change that.
I'll just put revisit.
But, okay.
We're okay.
Put okay,
We're okay at that.
okay change, you know.
Oh, my
that's-
okays mean we're not going back.
Right.
Right.
Well, then.
My revisit means we're gonna go back and
Okay,
change it.
I wrote change beside it, but.
Okay, revisit to change.
Revisit to change, yeah.
Any
Okay.
longer than 3 years probably would be unreasonable, but I
Yeah.
think 3 years is reasonable.
Well, we discussed that pretty thoroughly when we came to that.
It was a long negotiation, as I recall.
I think it was, yeah,
Blood on the wall.
yeah. We talked about neighbors, we talked about all kinds of things like that to justify our
People that live
costs.
here for a while and
That's
then
right.
go
Yeah,
away.
he's
Right, he's got to
Yeah.
get the feel of the city before he becomes
You
the
need-
village,
need to come
before
to
he
more of the
becomes the
meetings.
mayor, or she.
Yeah,
He was at that one.
At,
He could be the
Okay.
next mayor.
at some point, I know I'm interrupting, but when we were talking to the planning commission, and the discussion was, it was mayor and a council member having votes, and then a few other members. And I think part of the concern was, is that lining up the incumbents to be in positions of authority too much?
And that was a legitimate concern, I think.
Well, what I'm wondering is either here or, you know, where the mayor is ex officio member of all council committees, why would we give him a vote in the planning commission?
I think it's a
You know,
legitimate question.
as opposed to expanding the number of members, and there the counter argument is always, we can't find enough people to volunteer to fill the seats. If the city manager has no vote on anything but can attend anything, and the mayor can attend anything, the mayor's able to state his views, give his influence. But why would we give him a vote on the planning?
It's a legitimate point.
What section is that? Just so.
We haven't gotten
Oh,
to
we're not
that.
there yet.
We're getting there.
Other
We're working.
duties.
If we were revising mayor's duties, it's
Yeah.
either
You're in pink now.
early,
The horse is slowly climbing the stairs.
I appreciate your organization.
It don't have another color.
That might be another question to ask Jeff.
Yeah,
What section is that in?
304.
Oh, but, okay,
Isn't it?
that was my
Well,
question.
304 is one, where the planning commission is section 6.02.
Yeah, we're not there yet.
At the moment, it's 5 members. My notes from the discussion is we were talking about going to 7
Seven,
members
right?
to reduce the,
Oh, yeah, okay, I got that marked.
Yeah.
diplomatically correct, but,
Right, you were
In
saying if
order
there's
to
only
have
5 members, you got a councilman, you got the mayor,
and
and
you've got the mayor and council, so he just
that's
needs
really
one
only
vote.
leaves 2 citizens.
Yeah.
So, we could stay with 5 members and just say, just exclude the mayor. I'm fine with a council member.
You're in 6.
Yeah, I'm rattling on about 6.
Well, let's do that, and we'll get here.
Okay.
Don't forget what you're saying, what you think, and we'll get to that. I don't want to confuse our secretary or anybody else here. So.
That's not hard to do.
I'll bring some other highlighter colors.
She needs a
I
green.
did agree.
Yeah. I don't think I brought one.
I did blue and pink together, so I'm good. I won't forget.
Okay. We are at Article 4, manager.
You are. I'm at 4.04. No?
Yeah.
Yeah.
Okay, okay, that's where I'm at. Okay.
Article 4, manager, section 4.04.
Okay.
Mayor and council relation to manager. Is this the appropriate title of the section? And Jeff says, seems appropriate to me.
I'm sorry, with 4.03, we had the problem with state law saying we can't require residency within 12 months.
3.06.
Oh, it's 3.06.
Yeah, section 3.06, qualifications.
You know what? I have a note here regarding 4.03 on acting manager, but it wasn't a note for Jeff.
Yeah, we
My
have,
note was that we may, on the acting manager may need clarification, but it was not a Jeff question.
yeah, I had a couple of those.
On 4.02, just before that, but shall become a full-time resident within 12 months after appointment.
Mhm.
I
That-
thought-
We need to.
That
we have to
reword
remove that.
Yeah.
But it wasn't a Jeff question
Yeah.
because it was a state law that we couldn't.
So it's a green highlighter.
Yeah.
It's yellow. Doing so good.
Mine's yellow too.
That one was yellow because we knew that it was not really up for our discussion.
There was also a yellow in the 4.03 acting manager. Such designation shall not be effective until the council has approved it by a majority vote of the members of council, and the council may revoke such designation by a majority vote of the members thereof. We thought that was kind of a difficult statement, the way it's,
limited.
yeah, well, and it overlaps itself, all in one sentence, and we thought that needed to be reworked.
On 4.03, I'm just going to write revisit, just as a general.
Okay.
Yeah.
I think there was some discussion as to whether or not there should be just in the charter a designation who, in the event that the acting manager does not designate somebody by charter, someone automatically become the acting manager, whether it be a finance officer or chief of police or whatever. There was at least some discussion on that.
Yeah.
There was no final decision made.
Yeah.
Because we did have a situation come up this year where inadvertently there was no letter on file and everyone had to run around and backstop everything.
That's what I had highlighted was B, the council
Yeah.
may designate a person as acting manager shall exercise all powers to use function of manager. And that was why I did have that highlighted with the green by majority vote question mark, but it wasn't noted for Jeff.
Yeah, I had that same thing.
Okay.
And from our discussion, I inserted in here, in the event of a vacancy in the office of manager, the council, by majority vote, may designate a person as acting manager. That was inserted by majority vote. Somebody here worded it that way, and
Yeah, that's what I have by majority
Okay.
vote, so, in my notes.
yeah, so,
I think if you do that, though, you're gonna have to put some language in there excluding the mayor, because by charter, the mayor and city manager are separate offices.
the mayor does not have a vote unless there's a tie.
Yeah, but if you appoint him as city manager,
He's not likely to be the mayor is not likely.
not normally, but if you have a vacancy, and if you wanna appoint someone, in the council like the mayor, he can't serve because he can't be mayor and city manager at the same
True,
time under
and
the charter.
True, and the mayor is usually full-time employed. I mean, all of our mayors have been fully employed elsewhere and would not be able to take on a full-time
Right,
position of
and-
acting city
and
manager.
not
They
necessarily
wouldn't
true
be
in the
able to
future.
hold both positions.
Yeah, and it's illegal for them to hold both positions.
That's my point, you can't hold both
Right,
positions.
so, I mean, it's already taken care of.
Yeah.
I strongly suspect you're gonna have mayors in the future that will not be fully employed regardless of who wins.
Maybe,
Well, yeah.
maybe. Okay, 4.04, and that's a good catch, you know, that we do have some things that we didn't pass to Jeff because we didn't need to, you know.
Yeah, everything for Jeff was marked Jeff.
Yeah,
But then there were other things marked, like we need to go back, but it
Yeah.
wasn't marked for Jeff.
yeah. Section 4.04, mayor and council relation to manager, is this the appropriate title for this section? He says it seems appropriate to me. Is everybody okay with that?
Yeah.
Okay. And 4.06, removal of municipal manager from office. C and D are the timeframes okay? The timeframes seem fine to him. Is that all right with everybody? Section 502, law director. Council shall have the right to select additional legal counsel. Conflict of interest, any conflict of interest if law director represents an adjoining community. And Jeff says there may be a conflict of interest by representing an adjoining community, but only in certain limited circumstances such as annexations. I don't think it is worth adding anything to the charter about this. Council should just be aware of what the law director does and review situations on an as-needed basis. I think that's what we've always done.
I think you might want to look at it again, but that's everyone's, it's not my call. Because it's not only annexations, you have potential conflict. You've got police departments that work together under a compact. If something happens between the two police departments, not intentionally, but if it happens, you have liability issues. You've got two fire departments that work together.
Right.
Come here and go there.
Right.
That can create a potential conflict. Not that it hasn't yet, but
Well, there's a mutual aid agreement, and there's all kinds of language in there that protects both sides in the mutual aid situations.
But event it comes up for issue, if you have the same attorney representing both sides, and you got to, normally what the attorney would do, and I suspect Jeff would, is just back out of the case and refer the client, each client to someone else. That's what you're supposed to do.
When I run into that situation at work, the attorney says, the law firm, and it's 100 attorneys. We represent U.S. Bank and we represent you. You've got a problem with U.S. Bank, not problem, whatever it is, revising mortgage or some silliness. I have to give them a letter saying I agree to their representation. So I'm thinking, hopefully the ethics of the law profession would say we see a conflict and they would step forward.
We had that happen. They actually had that happen back in about 2003, police department and so on. And they backed it out and handed it over to the sheriff's department for a big investigation and stayed out of what was going on neutral. And
We're
so,
talking about attorneys here.
yeah, that was the whole law firm did. I mean, they
Yeah, once you knock one out, you knocked out the whole
Yeah.
firm, because that's what becomes the issue. And every lawyer can give you stories where they've had to back out of the case.
Yeah.
It's the nature of the business.